there is not a single statement, written or verbally, made threatening. There's no conduct threatening, no behavior whatsoever that would indicate any type of threat or inkling of violence towards the petitioner here.
Can I ask for another clarification, if possible?
Yes.
Under the Facebook pages thing, we're having some issue there with the respondent. The police did call. He's got a web page that he is the creator of, this World War III Japanese American internment page.
Mm-hmm.
He still has some memes up there of me, which would be in violation of the TPO because it's his, but he claims to the police that they went from closed to private.
Well, I guess is your position that your client can say whatever he wants about Mr. Moriwaki as long as it's in a closed group and it's not a violation of this order?
Temporary protection order, that was my understanding.
Mm-hmm.
But first of all, he hasn't been making any posts, period, since we're dealing with an old post beforehand. So
but it continues.
Well, he hasn't been writing anything more.
But it continues. He hasn't taken it down. That's the issue.
Well, he made it to private, yes.
Hasn't taken it down.
No, he hasn't taken it down, Your Honor, because I don't think that's what the temporary order said. It was talking about public web pages and Facebook pages. It's no longer public, Your Honor. I mean, I think at this point we're now going into First Amendment issues here.
No, we're not.
Please don't interrupt me. But point being is, he was following what the temporary order said. Public postings. It is not a public posting. It is a private Facebook page.
I would like more briefing regarding this issue. If he's in a closed Facebook group and he thinks that he can continue this, it concerns me that your client isn't getting it, that this petitioner feels harassed and he is encouraging further harassing behavior by having a group where he complains and makes memes and does all these things. He's not getting it. It concerns me that the response to this protection order would not be to take everything down and move on. That concerns the court. So I think that based on the information that I have so far that this is within the closed group and I want to have more information on it. I'm not going to amend my order at this time to prohibit you from doing something within a closed group. However, with the caveat that it is extremely concerning to the court and your right to do so may be future limited. There is not to be any sort of public postings about Mr. Moriwaki. I would consider old posts that were predated this order that continue to remain up as a continued harassment of him by their remaining there. So anything public that is being done towards the petitioner needs to be stopped. I think I'm trying to make myself very clear. Is it clear?
Well, I do have to ask. So is the court concluding that a private group is in fact a public posting?
No.
Okay.
I want further briefing on the issue for the full hearing. But at this time, anything that's public, anything that can be seen by anybody who comes along, and not saying that members of a closed group, needs to be taken down so that I'm very, very, very clear. And it may be that I rule further once I consider the case law and the evidence here about First Amendment issues. But like I said, it's sort of the principle of the matter. You need to leave this man alone. He doesn't want anything to do with you. He wants you to stop harassing him. He feels threatened. He feels your speech is infringing on his personal right to be safe, and it has to stop. And then the other one was submitted basically requesting that any mention of Mr. Moriwaki's name be removed from his Facebook page. And I can understand the desire on the fact of the petitioner of wanting to have his name removed. However, I don't think that that was exactly the court's intention. At the time, there was a Facebook page named Not Clarence Moriwaki, and there was a bunch of information that was posted on there that the court granted the temporary order based on, and that was more harassing in nature. And the information that was submitted by the petitioner was sort of old posts that were did not appear to be harassing in any way. We just referenced Mr. Moriwaki's name, and I don't think that was what the court's intent was to, that the respondent had to sanitize any listed name of Mr. Moriwaki. Does that make sense, Mr. Moriwaki?
Yeah, yes, I would strongly disagree on that point, but okay, on the second part, Your Honor, the whole point of the cyberstalking statute is the intent to harass, intimidate, torment, embarrass, and all the rest. And the statements do that. It's pushing me to try to kowtow to a position that he wants me to agree to, of which I do not agree with. And when he took down those posts, he took them down the same day that he closed the page and made it private. These posts, some of those were almost at the same time. So being of age or older is irrelevant. It's the content of what he's saying about me, because this is attacking my character. He's trying to say that I somehow refuse to do what he wishes. All that kind of behavior is, in its definition, stalking and harassment. So that's what those posts are.
This is a news report. This is the Associated Press report. This has been carried around the country. I'd like to draw your attention to the very last paragraph in this article. And he is Mr. Reinierson, and I'll read it. He took the page down, that page about me, from the temporary order, and ceased proceeding to criticize me. In response to the temporary protection order, he said in that declaration, but he, Reinierson, would like to resume the online criticism. He intends to continue the online harassment. And I recall your orders to him at the end of the last hearing. I believe you were speaking to counsel that said, and I'm paraphrasing, but perhaps it was, I don't think your client gets it, that I wish to be left alone. And here he is in the press saying, I'm trying to do this and get this case overturned because he wants to continue to harass me. He says it right here in the public record, right here in the newspaper. He isn't getting it. That's why this permanent protection order has to be given. He's proven his untrustworthiness. He's already proven his intent to continue the stalking and harassment. I need some relief. I've really had nightmares over this. It's been very grueling and very difficult in myself, personal relationships, and other issues. So I just need relief on this. I need a permanent protection order. The surrender of a weapon should be permanent as well, and you should not release his concealed weapons permit.
Right, thank you.
The petitioner is interchanging criticism with harassment, and that's not accurate. That's not true. To criticize an individual and to disagree with them is not harassment. And this goes into the heart of the Constitution and First Amendment. We're talking about a country that wants us to disagree. We want to disagree with people in power, whether it be politicians, other government officials, or other public figures. That is the heart of trying to make sure that there are checks and balances. And so to perceive any type of criticism or second guessing as harassment, that's just a very slippery slope, and it's frankly just not true. So what is this case about? As I alluded to before, it's about content. It's about what was actually being said. Because let's not kid ourselves. If my client was complimentary and just another constituent in the echo chamber saying, rah, 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 this is right, this is great job, great job, great job, we wouldn't be here. This would never have been an issue. Instead, the issue is my client disagrees with the petitioner's position and the things that he has done and has not done as a part of him being the face of the memorial. That's the crux of this issue here. This is a First Amendment case. Despite his objections to that and saying it's not, it is. And so the fact that my client chooses to bring up his disagreement with the petitioner and how he doesn't do his job as the spokesperson for the memorial is somehow harassment is ludicrous. It's not accurate, because my client believes the petitioner has a responsibility as the spokesman in the face of the memorial to place the interests and the goals of the memorial before his own personal political beliefs. Whether that is what everyone else agrees, so be it. But the point being is, it's a valid and it's a protected opinion. And he can say that. He can tell that to the community. He has a right to do that. The petitioner cannot avail himself of all the benefits of the media and talking publicly and try to get all the accolades, but the second somebody disagrees with him and criticizes him and says, hey, hold up here, I don't think you're doing your job, suddenly that's harassment? No, you have to take the good with the bad. That's the reality of it. He can snicker all he wants, but that's the truth. We have a right and we have an obligation to stand up and disagree. That's what the First Amendment is about, and that's what good citizenship is. Nothing happened here. Instead, what happened was my client posting on a public forum on Facebook his own personal message board and talking about his position, his politics, his disagreement. No threats, no indecent, vulgar speech, no threats, nothing of the sort. No defamation, nothing like that. Simply listing his opinion that the 2012 National Defense Authorization Act does, unfortunately, give the federal government the authority to indefinitely detain U.S. citizens. And it would make sense that who the community considers the key speaker on this topic to actually take a position on it, to criticize the legislature, to criticize the government who put this law into place. This is not some right-wing craziness. This is, and even if it was, it's still protected. But this is so normal that the Washington State Legislature actually created Senate Bill 5176 specifically to combat the NDAA of 2012. That's how mainstream this belief is. It's all here. It's all black and white. It's all before the court. Every single thing. And you will not find a threat in here. You will not find defamation. You will find repeated positions from my client disagreeing with him. Yes, we'll freely admit that. But whether he states it 1 time or 10 times or 50 times, protected speech is still protected. It is what it is. So it doesn't, simply because he's made his point 1 time, that's okay, but then the 10th time is no longer okay. That's not how the Constitution and freedom of speech works. What's protected is protected. He has the right to his peace and quiet in his house. Yes. He says, leave me alone. He's left him alone. He hasn't been calling him, he hasn't been texting him, he hasn't been sending him emails, he hasn't been sending letters. Nothing like this is happening. That said, my client doesn't have an obligation to allow the petitioner to remain in his little bubble. Each individual has the responsibility, their own responsibility, to avert their own eyes when there's something out there that they disagree with, if they don't like hearing. If somebody says something bad about me online, I don't like it. Yeah, I can understand that. But they have their opinions, they have their right to say that. I can choose simply not to go to that website that says things about me that I don't like. As long as they're not threatening me, as long as they're not defaming me, they have a right to do that. This is protected speech here. And it's even more protected because of who the petitioner is and because of the topics at hand here. This is the pinnacle of freedom of speech. Public figure, public forum, public interest topic. That's about as protected as we're going to be able to get.
I love how counsel always talks about he didn't say anything lewd or obscene. Well, of course, That's only part of the cyberstalking law, as you know. RCW 91.6.260, cyberstalking point 1. A person is guilty of cyberstalking if he or she, with the intent to harass, intimidate, torment, or embarrass any other person under any circumstances not constituting telephone harassment, makes an electronic communication to such other person or third party. Point B, anonymously to know repeatedly whether or not a conversation occurs. He did that. Cyberstalking does not have to be insulting, does not have to be swearing, does not have to have obscene words or be indecent, as the statute reads, and he did that to me. And that's clearly in my statement on March 10th and in my April statement as well. And this court made the correct decision to grant a temporary protection order on those grounds alone. Nothing has changed to change those facts that are in this record. It's about his behavior, and he's right, it's about content. He has a proven record of doing this. I pointed out, I don't have to go through it all over for you, but for his sake, he has been doing this to other blog sites for years.